Hello friends, Namaste to all. This is Ravindranath, the advocate from Vizag, Andhra Pradesh. Earlier I have made several videos in our regional language Telugu, and few people requested to make any video in Hindi or English language. Thereby I just want to make one video with the topic civil case steps. This video is only for juniors and not for experts. Please consider civil case steps, where a civil case begins and when it comes to end. In our legal language, civil case will starts with plaint and ends with judgment. Between plaint and judgment, the civil case several steps are there. I am going to explain the same. So civil case steps, to understand civil case steps, we have to know what is civil case. A civil case is a dispute in respect of a civil nature only. Civil nature is a dispute in respect of property issues, monetary transactions, and possession aspects, etc. Where no penal laws are applies is called civil nature. Civil case begins with plaint. That is, to institute a civil case, there must be two parties. Those are called as plaintiff and defendant. Plaintiff, the person who approached the Honorable Court, is called plaintiff under Order 1, Rule 1 of CPC, and against whom a civil case was instituted is called defendant under Order 1, Rule 3 of CPC. That is, plaintiff is explained in Order 1, Rule 1, and defendant is explained in Order 1, Rule 3 of CPC. Not a definition, complete definition is not there, but procedural aspect, that is, who may join as plaintiff and who may join as defendant, was available in Order 1, Rule 1 and Order 1, Rule 3 of CPC. Okay. Now, after presentation of plaint is nothing but an allegations made by the plaintiff seeking reliefs in the court of law against defendant. Plaint is not explained in CPC, but procedural aspects is there in CPC, Civil Procedure Code. That is, Order 4, Order 6, Order 7 and Section 26 of CPC is explained the plaint and particulars and how the presentation of plaint will be in the court of law. So, after filing plaint, the court will allot one number, and that is, after registration of plaint, the court will allot a number to plaint. That is, in our legal language, it will be called as OS, original suit number, so and so, by year, number of year, that is 2023. So after registration of plaint, the court will direct the plaintiff to issue summons to defendant. That is the second step in the civil case steps. What is service of summons? Service of summons is process, that is, the plaintiff, what is the plaintiff's allegation is to serve to the defendant to aware the defendant. Service of summons is explained in Order 5 of CPC. Issuance and service of summons is available in Order 5 of CPC. After receipt of summons, the defendant have to submit his answer, that is, written statement. The submission of written statement defense is called as written statement under Order 8, Rule 1 CPC, within 30 days to 90 days after receipt of summons by the defendant. So here several steps are already covered. That is, plaintiff filed the suit and court will direct the plaintiff to serve summons, and defendant has to appear before the Honorable Court and submit his defense by way of written statement under Order 8, Rule 1 CPC. After receiving plaint from the plaintiff and written statement from the defendant, court will adjourn the matter to issues. That is, court will consider that whether there is any dispute or not. from the plaintiff's allegation and defendant's defense. For example, here we will take one civil case, that is promissory note case. Plaintiff lent an amount of rupees 10 lakhs to defendant and defendant denies his allegation. Plaintiff came before the honorable court along with the promissory note document, but defendant denies the allegation that whatever the defense he may be taken, that is the signature is not valid, the signature not belongs to defendant, and suit is time barred. Several defense will be taken by the defendant through his written statement. Then court will adjourn the matter to the issues, that is whether really the plaintiff lent amount to the defendant, whether the defendant received the promissory note consideration or not. These are called as issues. So after issues will be framed by the honorable court, and before issues framed by the honorable court will give chance to both plaintiff and defendant for settlement of the disputes. That is, under section 89 of CPC, the court will give chance to both parties to, if there is any chance to settle the matter, they can, under section 89 of CPC. If both parties are not willing to settle the matter out of court, then court will frame the issues and post the matter to trial. That is, giving the direction to the plaintiff to submit his evidence. So the person who approaches before the honorable court needs to submit his evidence. Trial is nothing but direction given by the honorable court to both parties to submit their relevant evidence, respective evidence, before the honorable court in respect of their allegation and defense. So the person who approaches before the honorable court will have to submit his evidence before the honorable court. Sometimes defendant also can submit his defense evidence even earlier than the plaintiff under Order 18 Rule 1 of CPC, but this is a rarest case. Only under Order 18 Rule 1, when the defendant admits or denies a particular aspect of the allegation, then the court will give the direction to defendant to submit his evidence first under Order 18 Rule 1 of CPC. But in most of the cases, in 99% of cases, the plaintiff will submit his evidence earlier. So the evidence affidavit filed by the plaintiff is explained in Order 18 Rule 4 of CPC. When plaintiff submit his evidence, the defendant's counsel in person or defendant's counsel will cross-examine the plaintiff. That is, he has to give oath, the plaintiff will have to give oath and submit his evidence before the honorable court, and the other side party, nothing but defendant in person or his counsel, will cross-examine the witness. After complete of cross-examination of PW1, that is, plaintiff will be called as plaintiff's witness number 1 after his submission of evidence before the court. So PW1 evidence is completed, then the court will adjourn the matter to further evidence, if any, by the plaintiff. If plaintiff has more evidence, expect the plaintiff, then the other witnesses also have to appear before the honorable court and submit their evidence in favor of plaintiff. Those are called as PW2 and PW3, etc. Plaintiff witness 2, plaintiff witness 3, etc. All the witnesses in favor of the plaintiff on behalf of the plaintiff will appear before the honorable court, have to cross-examined by the defendant counsel. So after submission of complete the evidence of plaintiff, the honorable court will close the evidence of plaintiff and post the matter to defense evidence, that is, defendant's evidence. As the plaintiff appear before the honorable court, defendants also need to appear before the honorable court by submitting his evidence under Order 18 Rule 4 of CPC. When the defendant appear before the honorable court with his evidence, he will be called as DW1, defendant witness 1. Then the plaintiff's counsel will cross-examine the defendant in the before the court. After completion of DW1 evidence, court will adjourn the matter to further evidence of defendant. When if the defendant also have any witnesses in favor of him, then he will also produce them before the honorable court by way of DW2, DW3, etc. So all the witnesses appeared before the honorable court in favor of defendant, cross-examined by the plaintiff's counsel. After completion of defendant's evidence, the honorable court will adjourn the matter to arguments by closing the both side evidence. When the matter coming before the honorable court for arguments, then either plaintiff or defendant, either in person or through their counsels, have to submit their evidence, submit their arguments, either by way of oral or in written. This is explained in Order 18, Rule 2, Subclass 3A of CPC. So, after plaintiff, if plaintiff submit his argument first, then the defendant will submit his arguments in the later adjournment. Then the plaintiff has to submit his reply arguments also after completion of defendant's arguments. Then after completion of both side arguments, then the court will close the arguments and post the matter for judgment. This is the last step of civil cases, the judgment. Judgment is explained in Order 20 of CPC. So, after post the matter to judgment, the court will dispose the matter either in favor of the plaintiff or defendant basing on the evidence submitted by both parties. So, here these are the steps from plaint to judgment. So, these are the complete steps, and there may be several occasions these steps are altered in from the when the both parties will file any interlocutory applications, then the court will come, the steps will be altered to some other in other ways. That is, if the defendant did not appear before the honorable court in the first instance, the court will post the matter by setting him ex parte and direct the plaintiff to give his evidence immediately. Then after furnishing the evidence of the plaintiff, if the defendant come before the honorable court by IA, that is interlocutory application, seeking the honorable court to set aside the ex parte order passed against him, then the court will bounce back to written statement stage. So, I have explained in this video only the basic steps from the plaint to judgment. There may be several changes are there by filing any IAs. So, from plaint to judgment I have explained today. So, if you understand this topic, I am going to make further. So, please consider if any mistakes are there. So, thanks for watching. Namaste. This is Ravindranath, advocate from Vizag, Andhra Pradesh. Namaste.